year, 7 months, 29 days.
What is the offense?
Ambiguous lordship, 2020 B 2C and 25.
What was the contraband?
Contraband is
Ganja.
Ganja, lordship.
How much?
191 is
And the next date is 6/25 to 2025, lordship. For the copies, charges are not yet framed.
Charges are yet to be framed.
Yeah.
What is the allegation against you? It was found from your possession.
Was found from the vehicle which was from auto. He was driving that auto. And my case is that those contrabands were given by Ahmad Ali to carry those to another place, lordship. And he had no knowledge about those contrabands.
What he was carrying.
He was carrying. Without that consent or lordship. Possible. And the other person is granted bail by your lordship.
Where is the order?
That order, lordship, I could not annex in my petition, lordship.
Do you have it, a copy?
That probably that will not affect my case because the lordship granted him bail because nothing was recovered from his possession.
Okay. Which order? You can,
The file it is written, lordship, that case numbers are there. In the first page, in the file, lordship, there one notice given by the
who's
Ahmed Ali, lordship.
Ahmad Ali. Putul. Bail application 1480-2024. 1480-2024. 21/5/2024. Ahmed Ali. You are?
I am Rueluddin alias Jaki. This is my second application.
Where is your first rejection
That
order?
Page 31, lordship.
Yes, Mr. Goswami.
lordship.
Your ground is prolonged incarceration.
Yes.
And charges are yet to be framed, lordship. The total 12 witnesses are there. Page 23, your lordship will find.
Yes, you have any submission?
Lordship, my lord, what happened, my lord, now the other co-vehicles has also, my lord, he has also appeared, my lord. So it is fixed for, my lord, on February for the copies, my lord. Now the trial will begin, my lord. That is one of my submission, my lord. And secondly, my lord, my learned friend has said regarding that the driver is unknown of what he was carrying, my lord, in the auto, my lord. On that manner, your lordship can see the last order, your lordship. That submission has been made by in the earlier occasion also, lordship has definitely did, page 32, they have made the submission. That also may kindly see page 32. And the learned counsel for the petitioner submitted that the petitioner is the driver of the auto rickshaw from which a contraband was seized, and he was hired by one Ali Abdul to transport some goods from Uti to Chandika, and he was not aware that the goods which were transported.
How this can be proved? That
That of course
there
is a
may-
matter of track, but the difference is
No, no, but suppose assuming that a person hires a public transport and an auto van for transporting some of his goods. So whether the driver will examine everything what he is carrying, normally not. Normally not. Suppose while carrying the hired items from one place to other, a police raid is made and the driver is apprehended. Now, what defenses are available?
that conscious possession, that Mohanlal's judgment.
No,
will come.
but there are judgment of Supreme Courts which says that if driver is carrying some goods in his vehicle, it shall be presumed that he is having conscious possession,
So therefore, also I have said,
unless something contrary is shown.
therefore I have submitted that this is a matter of trial, because Lordship, ultimately, he have to prove it.
So,
through every
so
witnesses.
you, till trial, you have to be detained.
Probably on that ground it is there, but long incarceration Lordship may consider.
No, not in this case. I'm just asking, posing a general question.
If I have any documents to show that that the contraband which was found was seal packed at that moment when police raid it, in that case, Lordship, probably I can argue that this is not a conscious possession.
That is one.
Because now at this stage, I do not have any such document to show.
But burden is on the accused to show
The
that
burden
you
is
are
on the-
not.
Going by this order, my lord, thereafter lordship has dealt with it, and your lordship observation is that it appears that from the mere denial by the petitioner that he was not in a conscious possession of seized ganja, there is nothing to substantiate his submission to this effect. On the other hand, there are incriminating materials in the case record against the present petitioner as the present case involves contravention of commercial quantity. The embargo of section 37 is applicable in this case.
Okay,
It is
okay.
On the-
What is your submission regarding prolonged incarceration?
regarding prolonged incarceration, my lord. Since now the case is fixed for, my lord, earlier there is one absconder accused.
No, but you cannot take that plea, keeping a person behind the bar for 1 year, 7 months, and then say that now we are starting.
And in other submission is that, my lord, regarding the case, earlier section 436A, my lord, that in the CRPC, my lord. There also it is stated that 1.5 of the.
No, that operates in different field.
But applicable now, the NDPS as per.
No, it is applicable. My understanding is beyond one half of the punishment, you cannot detain him under any circumstance. He has a right under 436A, earlier 436. But
Beyond one.
But
But now,
the bail on the ground of prolonged incarceration stands on a different footing. It stands on the basis of right under Article 21.
that is, that has to be, my lord, appreciated by my lord, your losses, my lord, whether Article 21 has been violated in this case.
No, you are keeping him behind the bar for 1 year, 7 months, and trial is not yet started.
Such it, because, my lord, what the lordship will find from the, my lord, his detention period, my lord, the statutory period in, my lord, case of, my lord, NDPS is, and commercial quantity is 180 days, my lord. If going by that, or 6 months, my lord, is a statutory period given by the court, my lord, which is not in my humble understanding, my lord, which may not be counted on this aspect, because the court has given a 160 day, 180 days as a, my lord, statutory period, my lord, unlike the other cases where it is 60 days. One submission is there, my lord. And secondly, my lord, there, the section in, my lord, regarding the embargo of section 37, which has to be, my lord, fulfilled before, my lord, the satisfaction has been fulfilled, my lord, and so, my lord, whether he is, prima facie, he is not guilty of the offense, my lord, because the lordship will find, my lord, that it is not a case that, okay, my lord, there is a co-accused statement or other thing, my lord, that is a separate thing. My lord.
Which judgment you are relying?
The judgments, okay.
As per section 37, he has to certify that he is not prima facie guilty, but in this case, is it from the conscious position, a use all the.
No, suppose prima facie materials are there. Then how long can you keep him behind the bars during trial?
That is the, my lord,
That is
got
my,
to be decided in separate cases and separate.
no, suppose in this case, this question has arisen. How long can you keep him without his trial?
How long, my lord, that cannot be, my lord, I cannot be, my lord, at this stage, because there, there's a, my lord, witnesses, one may appear and other witnesses is, my lord,
So I am
cannot be
relying on.
stated at this stage, but what has been stated, my lord, that
What is this Ankur Chaudhary and Zakirul Islam?
Zakirul Islam is lordship against our High Court order, where his petition was rejected, and the Honorable Apex Court granted bail, considering that 1 year, 1.5 year. He
But
was in custody.
no,
and
no,
in
no
that case,
reasons have been mentioned.
That is mentioned, Lordship, Zakirul last line, Lordship. The petitioner has already undergone more than 1.5 years in jail. And in that case also, Lordship, that some of the witnesses were already examined, but in my case, Lordship, copies were not furnished till then.
No,
And-
my query is in Jakirul, how 37 was overcome?
Yes,
That-
As
yes,
regards that,
I-
no observation has been made.
that,
It only shows that in an NDPS case, Supreme Court can grant bail if the incarceration is 1 year, 6 months.
that for
but-
that, so I have given other two judgments, Ravi Prakash and Ankur Chaudhary.
Yes, Ravi Prakash, there is a mention.
yes,
In
sir.
Ankur,
Ankur, you Lordship will find, page 3. Page 3.
yes,
Down below page, the number is there. That second paragraph, now on examination, top your Lordship will get.
yes,
That punch witnesses have not supported the case of the prosecution. On facts, we are not
yes, yes.
inclined to
There is,
consider.
there is
It is
an
observed
observation.
from fourth line Lordship. It is to observe that failure to conclude the trial within a reasonable time resulting in prolonged incarceration militates against the precious fundamental right granted under Article 21 of the Constitution of India. And as such, conditional liberty overriding the statutory embargo created under Section 37(1)(b) of the NDPS Act may in such circumstances be considered.
Okay, heard, Mr.
Yes, yes, Ravi Prakash Khanna. So, this is a case where the witnesses were examined by the court, madam, and the court has come to a finding that section 30, because there has been stated that the funds witness has not supported the case at all. That is there, madam. That is why in a different circumstances that order has been passed, madam. This might not be relevant in this case because there no law has been discussed in that judgment, madam. But in this case, I am relying on my one judgment, that is why the Mohit Agarwal judgment, that is the constitutional judgment.
What it says.
It says, my lord, this I am reading the last line where the bail has been. In our opinion, narrow parameters of bail available under Section 37 of the Act have not been satisfied in the facts of the instance. At this stage, it is not safe to conclude that the respondent has successfully demonstrated that there are reasonable grounds to believe in criminal offence such as that he is not guilty of the offence alleged against him for him to have been admitted to bail. The length of the period of his custody or the fact that charge sheet has been filed and trial has commenced are by themselves not consideration that can be treated persuasive grounds for granting relief under Section 27. So these here the Honorable Apex Court in Fijal discussed that prolonged incarceration may not be a ground.
Where, read it, read
Yes.
it.
The length of the period of his custody or the fact that charge sheet has been filed, my lord. And
No, no, read properly.
yes, the length of the, I'm sorry, my lord, there is no soft.
No, read from your mobile.
The length of the period of his custody or the fact that charge sheet has been filed and a trial has commenced are by themselves not consideration that can be treated as persuasive grounds for granting relief to the respondent under Section 37 of the PPS Act. So, but as per this,
What is your submission on this?
The Lordship has already dealt with this issue because there was not, Article 21 was not there for consideration at that point of time. Probably Lordship that immediately after charge sheet that case came up before consideration. There was not, the argument was
Yes,
not that.
what was the period of detention that is,
That was
and,
not the argument.
and on this,
what is the
and another
citation of Mohit Agarwal?
criminal number, I'll send.
No, it is reported case.
Yes, the reported case.
I will get copy Lordship.
Okay, and I can give the minor and email kind of. And your lordship.
Okay, provide that Mohit Agarwal. Tomorrow I will deliver it.
I will give one another judgment where my lord bench has dealt with this aspect that it is the observation by the court that while passing the Ravi Prakash judgment, perhaps the court may not have been apprised of this judgment.
Then what is your observation on this Ankur Chaudhary? In Ankur Chaudhary also same observation has been made. Read para 2 at page 3 again. You have extra copy. Give a copy to Mr. Goswami. How this observation can be dealt with. Para 2. Please read it loudly.
Now on the examination.
Yes.
Now on examination, the funds witness have not supported the case of the prosecution. On facts, we are not inclined to consider the investigation as a funds witness. It is observed that failure to conclude the trial within a reasonable time resulting in prolonged incarceration militates against the precious fundamental right under Article 21 of Constitution India as such conditional authority overriding the statutory embargo created under may be considered.
So this, what I understand, says that if there is a prolonged incarceration, the fact that the embargo of section 37 is overridden by your right under Article 21 can be considered while considering an bail.
Yes. Right.
What?
But the observation is made in the Mohit Agarwal case, it is a minor constitutional case, minor, so I'm relying on with all respect, man.
I have given one copy of your lordship's order where lordship dealt with all.
Mohit Agarwal was considered.
Altogether 16 judgment your lordship has considered.
No, he is relying on Mohit
Mohit
Agarwal.
Agarwal was also- Lordship may kindly see the submissions of respondent, the citation given by. In paragraph 18, serial number 11. Narcotic Control Bureau versus Mohit Agarwal reported in.
No, but that was not discussed in the judgment.
But if it's fixed against the board,
For,
it is just
for delivery.
Delivery.
You have any submission?
no, but that the ordinance bench judgment. That the Mohit regarding Ravi Prakash has been discussed, man. That I can say. Only the judgment subject to consideration by the lawyers. Others, I really.
You give the citation of that judge, of Justice Surana.
Yes, perhaps not it is done.
You give the number
Yes,
of that case. We will take it out.
During that,
Your submission is that prolonged incarceration
in a different.
cannot be treated as a ground for overcoming the embargo of section 37. No, my query is how the judgments where Supreme Court has mentioned in the orders regarding 21 and 37 embargo and then granted bail have to be read by this court. In that you have to assist this court.
My lord, what I can understand, my lord, because the all cases, my lord, their facts and circumstances are.
Is it
different,
your
my lord.
submission that under no circumstances prolonged incarceration can be a ground where bail may be granted in NDPS cases?
Some cases, your
In
lordship.
what kind of cases?
Lordship has seen, my lord, in several cases, where 3 to 4 years, they are on bar, behind the bar, and no witnesses. were-
No, that I want to
Yeah.
understand.
Ravi Prakash also, my lord, perhaps it is the case, my lord, because.
No, therefore
in-
my query is,
So, my lord,
you are saying that the incarceration has to be longer than 1 year. Six.
as part of, my lord, 436, we have received earlier, and also as per, my lord, one observation is there in the second until also, my lord, that half of the punishment that is also discussed here. My lord.
Okay, then you give the judgment, copy of judgment of coordinate bench to by tomorrow.
Yes.
I'll deliver judgment. I will deal with these issues
Yes.
on Monday.
Yes.
On Monday, I will deliver.
I'm obliged. also.
Heard Mr. A. Ahmed, Learned Counsel for the petition. Also heard Mr. MP Goswami, Learned Additional Public Prosecutor. who submits that he will furnish a judgment of a coordinate bench of this court on which he is relying latest by tomorrow. So let this case be fixed again for delivery of orders. On 17th, Tuesday. On 17th.
Deeply obliged.
This is a lordship. It is a lordship. As per lordship, last order, the child court records of the conducted bail application 2828 has been tagged along with this present bail application. Only thing lordship called for a status report, which has not been received. And my lord, I find from the order sheet that 1212 is fixed for evidence, my lord. That is tomorrow.
12.
Yes, my lord.
How many witnesses have been examined till date?
My lord, only 3 witnesses.
How many are listed?
Listed witnesses,
10.
10 witnesses are there, my lord. Two of the co-accused were granted bail by this honorable court, which I have annexed, my lord.
How long you are behind the bars?
My lord, I am in, it is 2 years, 29 days. That is, my lord, 760 days as on today, my lord. As on
So you are mainly on the ground of prolonged incarceration.
Parity also, my lord, co-accused, my lord, the driver, the vehicle was also considered, my lord, on the same.
Okay. Then we'll fix this case again on 17th.
My lord.
17th, by that time, Mr. Goswami will be furnishing judgment and we'll go through the Mohit Agarwal's case.
My
We
lord,
will call for the status report by 17th.
yes,
Heard Mr. M.A. Chaudhary, learned counsel for the petitioner. Also heard Mr. M.P. Goswami, learned additional public prosecutor. The records of bail application number 2828/24 has been tagged. Putul, 2828 tag hoisen.
yes, my lord, it is there. 10 copies are there. There, my lord, all the depositions of PWs are there, my lord.
Okay.
Yes, yes.
The scanned copy of records of bail application number 2828 has been tagged with this case record. However, the up-to-date status report regarding the progress of trial of NDPS case number 160/2022 has not yet been received from the trial court. Issue reminder for the same. Registry to take steps for issuing the reminder. Let this matter be listed again on 17th of
December, my lord.
December.
My lord, one small player, I have filed one interlocutory application that is there in the record. My lord, on my, during my lord, there is a typographical mistake. Petitioner's name is Imdadul Haq alias Emdadul Haq. But I have, my lord, one A was inadvertently left out by typing, my lord. So I have filed this interlocutory application, my lord.
Where you have missed?
Lordship will find the main bail application, my lord. It is written as Imdadul alias Emadul, my lord. It is actually Emdadul, my lord. Amdadul. It is written as Emadul, my lord.
Heard Mr. M.A. Chaudhary, learned counsel for the petitioner. Also heard Mr. M.P. Goswami, learned additional public prosecutor. This interlocutory application has been filed by the petitioner, praying for unintentional typographical correction of unintentional typographical error which has crept in the bail application in respect of the name of the petitioner. It is submitted by learned counsel for the petitioner that in the cause title,
Yes, my lord.
name of the applicant has been
It is my lord Imdadul Haq alias Emdadul Haq.
typed as
Emadul.
in Imdadul Haq alias
Yes, Emdadul Haq, my lord, actual name.
AMDADUL. What should be the name?
Imdadul, my lord. Imdadul Haq is his actual name, my lord.
Only Imdadul.
Yes, my lord.
No alias is required.
My lord, in the records, my lord, is there as Emdadul. And Emdadul is there in the wrongly, my lord, it is there, my lord.
Now, what is the wrong? Let me understand.
Yes,
It is my lord, not Amadul, my lord. Huh?
yes,
Amadul,
not Ahmad.
In
not-
bail application in cause title, what is the error?
Imdadul Haq alias Emadul, I have, it is typed as Emadul.
Yes, you have mentioned Imdadul Haq alias Ahmadul Haq.
Emad-
What should be the?
Imdadul Haq alias Emdadul Haq. AMDAD.
he is missing.
Emdadul.
Okay. क्या लिखा? Alias AMADUL HAQUE. Whereas the correct name correct name of the petitioner is Imdadul Haq alias AMDADUL Haq. He prays for the correction, the leave. He prays for allowing the petitioner to correct this typographical mistake in the cause title of the bail application. Stop. Considering the error to be an unintentional typographical error, the prayer of the petitioner is allowed. How will you correct? You will submit.
My lord, as per the application, I will submit the corrected cost.
The petitioner is directed to submit the corrected cause title before the registry of this court
Tomorrow, my lord,
within a period of 2 days from the date of this order. This interlocutory application is accordingly disposed of.
thank you.